Hi, my name is Mustak and I'm going to do a presentation on property disputes of unmarried cohabitants on relationship breakdown. This presentation will focus on property disputes of unmarried cohabitants in the event of relationship breakdown when one party is in the sole legal owner. The case of Mustak versus Dowdent did not address this issue of how trusts arise in the context of sole ownership. It also did not clarify if making indirect financial contribution to the acquisition of property suffice to establish an interest. This presentation offers the view that there is further need for reform to level the playing field between the economically dominant party and the non-owner. This presentation considers whether allowing the courts to redistribute property between partners would be the right step, especially when the court needs to make financial order for the benefit of the children. A cohabiting couple is a couple who aren't married but live together. Cohabitant is not formally recognized as resulting in a family unit in the same way marriage and civil partnership is. Currently, the law determines cohabiting parties' rights on separation by reference to the law of contract, property, and trust. This amalgamation of different legal rules leads to complexity and uncertainty. A starting point assumption being whoever pays for the property owns it rather than a fairness test. Decisions such as proportional ownership and whether the property should be sold are made available for occupation by one party are examples of complex decision in the area. By law, cohabitants can make outright gifts to each other, can confer beneficial interest in property on each other through express trust or a contractual license. Particular importance has been placed on express declaration of a beneficial entitlement. In the case of Carlton versus Goodman in 2002, Lord Justice Wood urged for the conveyancers to include as a matter of standard procedure on expression from the purchasers on how the beneficial interest is to be held. Similarly, in Pettit versus Pettit in 1969, the logical conclusion is an express declaration. It can be argued that the constructive trust does enough to preserve the rights of the non-purchasing party in sole name cases. In Lord's Bank versus Rosette in 1991, even in the case where the couple were married, the court held that Mrs. Rosette's work on the house was not enough to form a equitable interest. In Gary versus Rankin 2012, the property was registered in Mr. Rankin's sole name. The court did not find that Mr. Rankin had intended that Mrs. Gary have a beneficial interest in the property, and she was not recognized until she divorced her ex-husband in 2002. In paragraph 63 and 69 of Mustak versus Dowden, Baroness Hale said, paragraph 63, there are differences between sole and joint name cases when trying to define the common intention or understanding between the parties. I know of no case in which a sole legal owner, there being no declaration of trust, has been held to hold the property on a beneficial joint tenancy. But a court may well hold that joint legal owners, there being no declaration of trust, are also beneficial joint tenants. Another difference is that it will almost always have been a concise decision to put the house into joint names. Even if the parties have not executed the transfer, they will usually, if not invariably, have executed the contract which precedes it. Committing oneself to spend large sum of money on a place to live is not normally done by accident or without giving in a moment thought. In paragraph 69, when a couple are joint owners of a home and jointly liable for the mortgage, the inference to be drawn from who pays for what may be very different from the inference to be drawn when only one is owner of the home. The arithmetical calculation of how much was paid by each is also likely to be less important. It will be easier to draw the inference that they intended that each should contribute as much to the household as they reasonably could, and that they would share the eventual benefit or burden equally. The parties' individual characters and personalities may also be a factor in deciding whether their true intention lay. In the cohabiting context, mercenary consideration may be more to the fore than they would be in marriage, but it should not be assumed that they always take pride or place over natural love and affection. At the end of the day, having taken all this into account, cases in which the joint legal owners are to be taken to have intended that their beneficial interest should be different from their legal interest will be very unusual. In paragraphs 16 and 17 of the judgment of the Lord Worker and Berners Hale in Jones versus Carnot, they said, paragraph 16, to the extent that we recognize that a common intention, trust is of central importance to joint names as well as single names cases. We are going some way to meet that hope. Nevertheless, it is important to point out that the starting point for analyzing is different in the two situations. That is so even though it may be necessary to inquire into the various circumstances and reasons why a house or flat has been acquired in a single name or a joint names. In paragraph 17, the starting point is different because the claimant whose name is not on the proprietorship register has the burden of establishing some sort of implied trust, normally what is now termed a common intention constructive trust. The claimant whose name is on the register starts in the absence of an express declaration of trust in different terms and subject to what is said below about resulting trust with the presumption or assumption of a beneficial joint tenancy. In Absden versus Ilvi in 2012, the property at the heart of the dispute was purchased by Mr. Absden. However, Ms. Ilvi put forward that she had an interest in the property from the day it was bought. Both parties asserted that they carried out work on the property. Later, Mrs. Selby convinced Mr. Aspden to transfer the property to her name, which he did. The view was that Mrs. Selby became the legal and equitable owner of the Outletty Bun following the completion of the registration on 25th of January 2006. The court also found that the contribution made by Mrs. Aspan were not intended to be gifts, and therefore Mr. Aspan's share was calculated at 25%. Historically, there has been a push to differentiate the rights of married couples and cohabitants for the purpose of supporting what is seen to be a more stable social unit. In the 1998 Green Paper, the Labour government made it clear its preference for marriage. It is suggested, however, that a reformed the law for cohabiting will not negatively impact the institution of marriage because generally couples do not marry to get the benefit from the law, rather to satisfy religious, cultural, social, and personal reasons. Because cohabiting couples are usually unaware of the lack of protection afforded to them upon the event of a dissolution of the relationship, effective steps to protect interest are not taken. Due to this, it is felt that the law should do more to create this level of protection. In research by Barlow and Jones, 56% of the couple interviewed believed that they would receive protection from the law in the event of property dispute. This is otherwise known as the common law marriage myth, the false belief that unmarried couples after a certain length of time are treated as though married and have access to the statutory remedies to deal with the financial consequences of the breakdown of a relationship. Improving public knowledge of the law is one potential remedy, as it will allow couples to make informed decisions on marriage or how to clearly outline their intention for property ownership. According to the Office of the National Statistics, in 1979, 11% of women aged between 18 to 49 were cohabiting. By 2001, this had risen to 32%. The proportion trend reports of 2005 suggest that within 25 years more couples will be cohabiting than married, and the figure of 2 million cohabiting couples in 2003 will reach 3.8 million in 2031. This figure supports the need for the reform on the basis that cohabiting is becoming just as normalized as marriage. By not legislating more strongly for cohabitants, there is a huge void leaving particularly women and children vulnerable. However, there are a broad range of cohabiting relationships, and it is felt that because cohabitants have not made the distinct legal and public commitment to marriage, they should not be afforded the benefits. The 2007 Law Commission proposal forged a way forward. Having children together, staying together for a specified minimum terms, and making qualifying financial contribution are all suggested hurdles before protection can be afforded in the event of separation. Currently, no action is being taken on these proposals, but this presentation suggests that this would be a great step forward, balancing the rights of cohabiting couples and preserving the legal benefits awarded to the commitment of marriage. There are some references for you to look at in details, and thank you very much for listening this presentation. Thank you once again. I hope you enjoyed it.